Good morning. We'll hear argument in 22-180, CAE Simuflite and American Flyers versus Talavera from Dallas County and the Fifth Court of Appeals District. Justice Boyd cannot be present this morning, but expects to participate in the decision of the case. Representing the petitioner CAE Simuflite is Blake Bailey. Petitioner American Flyers is John Harrison. And representing the respondents is Stephen Aldis. Mr. Bailey, we're ready to hear from you.
Thank you, Your Honor. May it please the court. This case presents an important issue not only to Texas jurisprudence, but also to the nation, as this is the first state Supreme Court to address the application of the educational malpractice doctrine in the aviation context. The only prior pronouncement with respect to Texas law was a decision by the District Court of Kansas interpreting Texas law, and really a secondhand interpretation. The trial court certified three questions for interlocutory appeal. The first was whether or not this claim is itself a claim for educational malpractice. The second was whether educational malpractice should be rejected as a viable cause of action in Texas. Now, my interpretation is that the respondents essentially concede these first two questions, and instead they urge this court to adopt a special exception to the educational malpractice doctrine and to allow claims for negligent training against a private for-profit company teaching on a specialized piece of equipment such as an airplane.
So, Mr. Bailey, let me ask you, aren't negligent claims against employers having to do with training pretty common?
Yes, Your Honor, and this court in the Pagion case, as you know, did not decide whether or not the negligent training claim was a viable cause of action in Texas against an employer. But in this instance, it's a very different situation because you're imposing a duty that is addressed by the conduct of a student once they are outside the control of the trainer. These claims arise only in the context of training is complete and the pilot is out flying the airplane on their own outside the control of the trainer, and is based on their conduct at that point. It really extends a concept of vicarious liability of creating a special relationship between the instructor and the student that continues after that relationship is over and tries to hold the trainer responsible for the conduct of the student. And that's
so is that the limit of the educational malpractice rule that you're advocating, that if you're outside the control of the trainer, then the rule would come into effect?
That's all that is necessary in this case, Your Honor, is with respect to whether an instructor has liability and responsibility for the conduct of the student after the training is complete and the pilot or the trainee is operating on their own. When we create a legal duty in a negligence case, it's not just a standard of how the person is supposed to conduct themselves. It's a standard that creates liability if the student conducts themselves otherwise in the future. And that's one of the big policy considerations that has led to the bar on educational malpractice claims. The first question, of course, is whether it is educational malpractice or not. And like I say, I think that's pretty well been conceded. But both the Dallas Automotive case and the Waugh case out of the Illinois Court of Appeals instruct that you need to look at the substance of the claim and the nature of the claim to determine whether it is in fact a claim for educational malpractice. And the Dallas Automotive case, it has a litany of different claims that have been asserted. That's basically, it says if it walks like a duck, it's a duck. It says when you look at the claim itself and say, is the claim one to educate effectively and require the court to evaluate the content of the instruction and the soundness of the teaching, then it's educational malpractice. The courts that have looked at this, and the most recent case, I really want to commend to the court's consideration, the most recent case to evaluate the application of educational malpractice, in particular in aviation context, was out of the Court of Appeals in Pennsylvania, the Grady versus Aerotech case, which is cited in our principal brief. Although I think we said it was the 23rd edition of the Atlantic Reporter. Of course, it's actually the 3rd edition of the Atlantic Reporter. But in that case, the court sets forth one of the most thorough analyses of the policy considerations, the application for the educational malpractice bar to aviation cases, and goes through an analysis of each of the key cases in federal and state court, including its analysis of the Kansas district court's guess with respect to Texas law, and criticizes and points out the errors in the Kansas court's pronouncement of what Texas law is and why allowing those claims is contrary to public policy. The exception that the respondents urge the court to adopt here of allowing negligent training cases against for-profit companies teaching in aviation is based on the Middle District of Florida decision in the Newman versus Cicada case, which actually, when you read the case, does not create an exception. It treats that case as a failure to warn. But as the Pennsylvania Court of Appeals points out in Grady, the policy considerations behind general education malpractice apply equally in the case of aviation training, because you have difficulty with respect to defining the duty. You're looking at defining the duty not based on the teacher, but based on the future conduct of the student and why that student has not complied or conformed their conduct to the training itself.
I take it your position is it doesn't matter whether it's cast as a failure to warn claim or some other sort of negligence, that even if the educator fails to pass on a clear warning, you would say that say in the materials that come from the engine manufacturer or from the plane manufacturer, don't fly this plane above 7,000 RPMs or the engine will explode. If they fail to pass on that warning, if the person doing the instruction fails to pass on that warning to the trainee, you would say, go sue the engine manufacturer or the airplane manufacturer. We're not liable for that.
Correct, Your Honor. In the Glorvigan case, the instructor in that case was accused of skipping a chapter in the curriculum on the operation of the autopilot. And the court held that ultimately it is the pilot that is responsible and the student that's responsible for their training, their knowledge, and implementing that knowledge.
So even if there were left behind, say, in one of these decedent's rooms, a copy of the materials that were used for training, and it showed that there was no warning in there that, in my hypothetical, if you run the engines above a certain RPM, they're going to explode. And a black box were to show that that's what happened, that the engines were run above a certain RPM and then they exploded, you would say no liability.
We would, Your Honor, because again, you're putting the court in the position, you're doing two things that violate public policy. You're putting the courts in the position of evaluating and determining what the content of the training should be. And again, in the Glorvigan case and Sheasley both state, and Grady, I'm sorry, in the Glorvigan case and in Grady, they both state that the content of the instruction is not something that should be determined by the courts. And I would submit certainly not by the juries in hindsight, that the content of the training and the regulation of the training should be left to the regulatory body responsible for that trainer. Whether
Well,
it's
Mr. Bailey, go ahead. Was someone else asking? Go ahead.
I was going to say whether it's a school board or the FAA, or whether it's a commercial truck driving instruction that's being governed by TxDOT, the regulatory body that is responsible for that training and certifying those pilots or those drivers, the doctors or lawyers, are the ones that should be the ones determining the content. Would your position be the same if the black box showed that not just that there was some portion of the curriculum omitted that someone thinks ought to have been included, but that there was an affirmative mistake by the trainer? That, for example, the trainer had said to the pilots, well, if this happens, if there are these conditions, the way to land the plane safely is to turn this dial to the left. And in fact, the proper instruction that the manufacturer recommends is to turn the dial to the right. What if the black box had recorded that? Well, I think that's irrelevant whether the black box records that or not, because the issue is, was the pilot error? The black box would record what the pilot error was potentially, but it does not necessarily establish the causation that the reason the pilot engaged in that conduct was based on faulty training.
But if you had the training manual to show that turn the dial to the left is what was said, what then?
I think it's the same thing, Your Honor, because we're creating a form of liability that assumes that the reason that the pilot did that act, turn the dial to the left, was because the instructor had told them to turn the dial to the left.
Yes, but just in my hypothetical, just assume that the black box says, the pilot is saying to his co-pilot, oh, the trainer told us last week to turn this to the left, so I'm going to do it. Under your theory, I hear you to say there should not be a claim even in that circumstance, which, admittedly would be unlikely. But is that just the cost of your theory? Is it some claims where causation there might be a fact issue on causation if the claim were allowed to proceed? They just, as a matter of public policy, ought not be allowed.
That's exactly right, Your Honor. That as a matter of public policy, that claim should not be allowed because of the fact that you're expanding the duty to be measured by the conduct of the student in the future. You're going to multiply litigation extensively because every truck driving accident, every plane crash, every botched surgery becomes two pieces of litigation, one against the actor and one against the trainer. And
in products liability cases, in particular pharmaceutical cases, there's the learned intermediary doctrine where the manufacturer can say as a defense, we passed along our warning to a learned intermediary, and so that our obligation to the end user of the product is complete. How does that doctrine interplay with whether or not to recognize a cause of action here?
No, I think I think the interplay with that would be similar to what the Glorvigan and Sheasley cases state, that it is ultimately the responsibility of the student with respect to knowing their limits and knowing how to operate and their aircraft and use those flight manuals that are, if we're dealing with a truck, learning and using those manuals with respect to how to operate the equipment themselves.
Well, but Mr. Bailey, how isn't that kind of putting the burden on the student who's a student for a reason? Because the student needs to learn. And if the teacher says, turn the knob to the left, when in fact the knob needs to be turned to the right, how in the world would the student ever know that?
Well, I liken it to law school when we all sit there in a class and there's 150 students in the class. Well, let me back up one step. The law school does not teach us every single thing that we have to know to practice law. It doesn't tell us every single thing in every case to do. It gives you the basis.
Hopefully somebody's teaching the pilots everything they need to do to fly the plane.
Right.
Well, it's a combination of things, Your Honor, with respect to pilots. They are required to go through training every single year and get recurrent training, just like a lot of professionals are required to do as well. And in any class, you can't teach every single skill. It is ultimately the pilot's responsibility under the federal aviation regulations with respect to how to operate the airplane. And I agree, with Justice Lerman and Justice Bland, we can come up with a scenario where the perfect situation could apply, where we could show that the instruction was faulty. And if the pilot said, hey, I remember my instructor saying, ignore the operational ceiling of the airplane and fly higher. You could come up with a situation like that where you could say this ties, but it would be so rare to be able to do that. And you're opening up this Pandora's box with respect to potential claims where juries are going to be evaluating the training in hindsight and determining that the reason that this student acted in any case in a way that was pilot error was because the training was not there, or even even if it was in the materials, it wasn't emphasized hard enough. So when you're getting into in all those cases, you're getting into, evaluating the criteria and the substance of the training, the content, and how it is delivered, which the courts have universally rejected as a proper basis to establish continuing liability going on forever for a teacher.
Mr. Bailey,
the student.
Mr. Bailey, could you address the breach of contract claim and how that whether you concede that should be treated at all differently from the negligence claims, insofar as, if you posit that there could be not necessarily in this case, I don't see something like this pled in this case, but there could be a case where the contract or the flight school makes a representation that you're going to get something that the student later contends was not delivered, that the performance, that there was a contractual duty, a specific contractual duty to deliver, say, 60 hours of flight time, and the school only delivered 40 before saying the training session is over. What about that breach of contract theory, if it were pled?
I can see a situation as you just described and would agree with you that a breach of contract claim that is a failure to provide the services. And your example is exactly right. If there was an agreement to provide 3 days worth of simulator training and they only provide one, then I think you've got a situation where they've contractually agreed to do something and haven't. But if you're looking at the
and so
breach
in
of
that
contract claim
case,
here,
in that case, do you agree that a Rule 91A motion should be denied and it shouldn't be granted just because the defendant happens to be a private for-profit flight training school?
you have to look at the substance of the claim to determine, is this a claim for a breach of contract where there's a substantial breach of contract, or is it a claim for negligent training? The contract claim in this case is very clearly pled to be assuming tort duties and breached by the negligent training. So
But
if the
for
substance
example,
of the claim is
if you had a
negligence,
situation where an airline decided to subcontract out their flight training, I don't know if this happens in real life, but just as a hypothetical, if some airline hires one of the parties here to do their flight training, and so there's a contractual relationship between the airline and the flight training school, and you can prove that a certain type of training that was contracted to be provided wasn't provided, and that led to a crash that the airline is being sued for, can the airline then turn around and sue the flight training company that they contracted with to provide this training, saying you didn't provide this training and that's what led to this crash?
I think, again, if there was a failure to perform the contract, substantial breach of the contract, then there would be a cause of action for breach of contract. But if the claim was that you were negligent in providing the training or you didn't teach them well enough, then that is walking directly into the educational malpractice bar. So you have to look at the substance of the claim. That's what, and Grady, again, I go back to the Pennsylvania Court of Appeals decision. It stated that it's impossible to create any sort of an exception limited to for-profit flight training centers, and that the exception would swallow the rule because all the policy issues still exist. And you have to analyze, if you're putting the court or the jury in the position of analyzing the content of the instruction or how it's delivered, then it's a violation of public policy and that claim should not be permitted.
Any other questions? Thank you, Mr. Bailey. Mr. Aldis, we'll hear from you.
Thank you, Your Honor. May it please the court. I'd like to start off just by reminding everybody, and of course I know that everybody knows this, but we're here on basically a interlocutory appeal on a motion to dismiss. If the court wants to review whether or not the order that the trial court entered denying the motion to dismiss, then I think it's clear that, or I hope that the court would provide guidance to the trial courts that when a cause of action has no basis in law, if the allegations taken as true together with the inferences reasonably drawn from them do not entitle the claimant to the relief sought. Now, the petitioners here had the burden of demonstrating that the cause of action has no basis in law. And when there has been no decision by any of the appellate courts in the state of Texas regarding the specific cause of action alleged, shouldn't the trial court then deny the motion to dismiss and say the burden hasn't been carried? In that context, if you're reviewing whether or not the trial court actually entered the correct order, then that's one thing. Although I recognize that the permissive appeal aspect of it is basically saying, hey, I'm going to let you review this and see if you would have made the same decision. But if this court says that the decision, then I'm just going to skip over what 91A requires and go straight to the meat of the argument. I believe that that's not going to help the trial courts decide when and how they should rule on motions to dismiss where there's no authority in the state that basically prevents the cause of action for moving forward.
It's neither way. It hasn't been recognized or foreclosed either one.
That's correct, Your Honor. And I think that what we really are looking at is a sector of the aviation industry that's asking for blanket immunity. Justice Lehrman, you are absolutely correct that airlines get sued all the time for their negligent training of their pilots. Now, Mr. Bailey tries to distinguish that by saying, well, they're still under the employ of the airline at the time of the negligent act. But still, the issues of whether or not there's a standard of care for that, whether or not there is all those other things that just basically dispute the traditional educational malpractice claims, that just doesn't exist in this context. And Justice Busby, you're absolutely correct. Many of the airlines do third party out or subcontract their training to other entities. And so
are there any cases where airlines have sued those entities?
Well, I just know that there are cases where that allegation has been made against the Flight Safety International, for instance. In the cases that we cited, they actually did the training separate and apart from, they were hired by the airline to do it. And my recollection is the Tristan versus the Central District of California case cited in our papers has that. But I think that the petitioners used the phrase educational malpractice 100 times in their opening brief and 50 times in their reply brief. So I'd like to step back and just say that the label doesn't fit, and you shouldn't just rely on a label. The question here is not whether or not you should recognize a cause of action. The question you have is whether or not you should recognize that the petitioners in this case owed a duty to do what they said they were going to do in accordance with the federal air regulations. These entities are regulated under Part 142 of the FARs, and they have many different requirements for these outfits. And one of them is they have to submit their curriculum. They have to have it approved. And so they set forth what they're going to teach. And if they don't teach those things, then wouldn't that be a breach of a duty created by the FARs?
Well,
Also,
we've said in the drug testing context that where there are regulations on point and the administrative agency has the power to police whether they've been complied with, that weighs against the recognition of a duty. So what would your response be to that?
Well, in Kraut versus Haverfield International, Inc., it was from the Western District of New York. What it basically was is the court analyzed whether or not the FAA regulations completely preempted New York law of negligence. And what the court basically said is, no, it doesn't completely preempt. It does. It is invasive in terms of the air safety, but what you do is you substitute the standard in the FARs for instead of the reasonably prudent person, it may be reckless and careless as set forth in the FARs. So the question here is really, is there a duty? Because negligence has been recognized by the state of Texas for longer than I've been practicing law. And I assume longer than all of you have too. But the point of it is that when you get down to it, the question of whether or not a duty is owed is one of the things that the court decides based upon all the facts and circumstances surrounding the case. At the pleading stage, I would submit to you that you don't have the sufficient information to make an intelligent, well, not an intelligent, that would probably be a misspeak, but you don't have enough information to make the type of decision that you would want to make relating to this very important issue. It's not like the petitioners will lack procedural remedies if the court sends this back to the trial court. Those procedural remedies include motions for summary judgment that they can file with evidence, which would be then we would also come back with our own evidence, and then we can make a decision based upon a factual record as opposed to the cold pleading. I just submit to you that the Rule 91A does not have application in this particular case. And I also believe that the case law setting forth there's really 4 cases that support Mr. Bailey's position. And then there's 4 cases or 3 that support our position. And if you look at the reasoning about why the court in Sakata denied the motion to dismiss, it's because the judge said, I can't believe that the state of Florida would grant immunity to a for-profit entity teaching pilots how to fly. And a motion to dismiss under federal law is very much like a motion to dismiss under Rule 91A. Is there any possibility based upon the facts alleged that you can make a claim? They also, in the NRA air crash near Clarence Center, New York, cited in our paper, that came to the court on a motion to remand after it was removed to federal court. The case was removed to federal court, and the defense in that case basically said that the flight school was improvidently joined, I guess the old fraudulent joinder, but now it's improvidently joined, and claimed that there was no cause of action that could be asserted against the flight school. And the New York court in that case also said, no, that's not the case. And that's very much like the 91A standard too. Is there any possibility that a claim could be stated against the non-diverse defendant? And so in both of those cases, they recognize that the policy considerations that courts have used to basically support a ban on educational malpractice in the traditional educational sense simply don't apply here.
Yes, but could I ask you, just in terms of responding to the problem of the floodgates that's been raised, of opening floodgates, why would a duty obtain in the context of flight training and not, for example, the kind of training, driver's ed training that teenagers tend to take when you go and apply for a Texas driver's license? What is the difference? If you can articulate one. I can't find a difference. So there have been lots of car accidents this week. Why wouldn't, under your theory, there also need to be a duty that would say anyone who's been in a car accident this week has a cause of action against the company, the for-profit company that gave them driver's ed training, whether that's a year ago or a decade ago or more?
Well, what I would say is each one of those situations should be evaluated based upon the facts of that case. I agree with you. It sounds ridiculous to say that every time there's a car wreck, I'm going to go back and drag up the person who did the driver's ed. However, that's the floodgates argument doesn't really work with respect to an airplane crash case and the training provided by a third-party commercial entity for profit that's holding themselves out as someone who can do this. Those are just simply separate. And the fact that you might have situations where the training was recent, where the training covered a specific airplane, as in this case, and whether or not that company followed the protocols and the other things that were part of their filings with the FAA. So all of those are traditional duty, breach, causation type issues. And we do that all the time with professionals in the medical malpractice context. They take actions, and then we allow the juries to basically evaluate whether or not that physician or hospital fell below the standard of care. There's no question that
do we, in the medical malpractice context, allow them to see whether the medical school professor fell below the standard of care?
No, not necessarily. There's nobody that that I'm aware of that has gone back and sued a medical school saying that they received an improper education, but that's not the same thing as here. Because
Surgeon, there's a recording in the surgery where the surgeon says, well, my professor at medical school says that when you get to this part of the heart, you cut left, even though this guidance says you cut right.
well, I still dispute the substance of that, because what I would say a more likely scenario would be if a doctor goes and gets trained on a new machine, a laser, for instance, and that training is faulty in that it says he turned the laser too high, but they told him to do it, then that would be what, then you sue the doctor, and the doctor's going to say, wait a minute, I need to sue the training people because they told me to put it on 7,000 whatever. That's the way it should go. But should that trainer?
But isn't there a difference there, though? If the person who paid for the training is suing the training company, saying, "Yeah, they're suing me because I turned the laser too high and injured this person," but I paid you to train me on this, and you didn't do it right, and that's why. And so it's like an indemnity and contribution type situation. That seems different from what we have here, because I couldn't tell from the briefs, but did either one of the decedents in this case pay for the training?
Well, there's a breach of contract action that was alleged, but mainly for the purpose of saying that a duty could have come about from the contract. But I don't recall.
But was there a contract between the pilot was there a contract here between the pilot and the training company, or was the contract with somebody else?
I don't recall that it's actually in any of the pleadings such that it could have been evaluated by the trial court. And I'm not aware that it's in the pleadings such that this court could evaluate it too. So as a result, if I said anything at this point, it'd just be me saying whatever I'm saying, as opposed to giving you a record reference. In the traditional educational malpractice type case, where someone wants to sue the University of Texas because they didn't teach Steve how to read well, and Steve can't get a job now, there are great policy concerns and reasons for excluding any of that type of claim. Also, claims that you failed to recognize that I had ADHD when I was in high school, I would have had better grades, and I could have gone to Harvard instead of Houston. So, that's the way those claims should be excluded. But these claims are not as much like that, such that they should be lumped together with those other claims.
And so what's the line? What's the line between the two?
Well, I think that the line is going to end up being individual situations where the educational malpractice line, where we know that anything that goes against a secondary school or a public institution saying general allegations of you didn't educate me well, those are out. But when you have a specific training program for a specific airplane being offered by a trainer, and that those people then go out and provide that training, if it falls below what the standard should be for that training, then they should be held responsible, just like any other professional that operates in the state of Texas. And as far as the line, Your Honor, I don't think this case is for drawing the line for all aspects, because I don't think you can do it at the pleading stage. I don't think there's enough information to do it. And I think that development of the facts would allow the court to actually, at some later date, to evaluate whether or not that line is appropriate in this case.
But you think that there are some cases where an early dismissal would be appropriate, right?
Yes, I struggle. I struggle with that a little bit, because what I'm basically saying, the whole reason for the statute, which is to allow these legal questions to come forward at an early basis, I don't dispute that. But the question I have is whether or not on this 91A at the pleading stage, that this is the place to start drawing the lines. I think that if we went back, for instance, and the trial judge was inclined to deny a motion for summary judgment based upon the same facts because of a record that's been developed. And at that point in time, you know, that would be a time to save additional resources. But at this point in time, that's why I started out. If it has been foreclosed by a case from this court or from even a court of appeals, if some court in the state of Texas had said, you can't sue this flight school for negligent training because it is just not a cause, we don't recognize that duty, then I would say this would have been appropriate. But since there has been no decision, my statement is it should not be dismissed at the 91A stage. I hope that kind of explains my position. I'm doing it. So I think the other things too, with regard to the traditional malpractice claim is impossibility to prove the alleged malpractice of the teacher approximately caused the harm. Well, as Justice Huddle said, you know, what if we have evidence that he was trained to turn the dial to the right, should have turned the dial to the left? Well, that would seem to be causation if the cause of the crash was failure to turn the dial to the left. That's just traditional approximate cause analysis. Whether or not theories of education are not uniform, different but acceptable scientific methods of academic training, and it's hard to formulate a standard by which the defendant should be judged. Well, that's not the case here because the FAR set out what's required by these schools in terms of their itinerary, their curriculum and all that, and they have to file that. If they complied with the FARs, that may be a standard of care issue that they win on, but that is a different question than whether or not they owe a duty. One of the other reasons that courts have rejected what I call traditional educational malpractice cases is that the courts fear the increase of potential flood of litigation. I don't see that as the case in this situation because the issues, as you know, we discussed earlier, a lot of times the airline is sued for failing to train their pilots in the appropriate manner, and they deal with that claim just like every other claim. And finally, you know, in the educational malpractice context, they say that what the court shouldn't step in and basically take over the schools. And I totally agree. And in this context, it won't be that way because there will be no court oversight of whether or not the petitioners provided the correct curriculum because that's done by the FAA. So just in short, this is not the right procedural setting to determine whether or not a duty is owed because we don't have some of the facts that might go into your decision. And but even if you did, I guess the basis for barring traditional educational malpractice cases do not apply in this situation. Thank you for your time.
Any other questions? Thank you, Mr. Aldis.
Thank you, Your Honor.
Mr. Harrison, I believe you have 3 minutes for rebuttal.
Okay. All right. John Harrison here for American Flyers. May it please the court. I only have 3 minutes, so I'm going to hit the highlights here. Justice Huddle, I believe you were absolutely right when you asked, what about the floodgates that are going to be caused by recognizing this cause of action? So very quickly, I'd like to talk about some of the ramifications that will happen if this court does recognize the cause of action that respondents are asking you to do. First of all, we will get a flood of litigation. People throw that around like it's a threat. So how would it actually work? In every aviation crash case in the state of Texas, from here until the end of time, you're going to create a new class of defendant. You're going to have flight academies, flight instructors, anybody who has anything to do with instructing the pilot is going to be included. Normally in an aviation lawsuit, you'll have the maintenance company that potentially made an error on the aircraft. The manufacturer might have done a products liability case, something like that. Now you're going to add a new class of defendant with these instruction companies. And it's not always a company. Sometimes it's just a person who's an FAA certified flight instructor. They can be
Mr.
individuals.
Harrison, does the FAA investigate and impose penalties against flight companies or flight instructors for faulty training?
I have seen where flight instruction companies have been penalized for being involved in an accident. I do not have any knowledge of a pilot having left a instruction company and causing an accident or being involved in an accident and the FAA traveling back to that original instruction company some 5-10 years earlier and finding them for that. No, I have never seen that, but that's the limit of my own knowledge.
Regarding, I want to ask you about the breach of contract claim here, because your colleague in his opening argument said that would be a different situation. Say if the airline is the one that's contracting for the training, and then sues the training company and says the training was faulty. Do we know whether that's the situation here? Your opposing counsel said we don't have enough information from the pleadings to know who the contract was with here. As far as whether the contract was between any of the deceased pilots and your clients, or whether it was between just for their benefit, basically. Do we know who the contracting parties are, or can we not know that at this stage?
Well, I know it's not in the record. I will say that generally speaking, it is not the pilot who has the contract with the flight company. It's the owner of the aircraft or a flight service that pays for it. I think that if we're discussing the breach of contract issue, I believe that Mr. Aldous said that we are asking for blanket immunity. I would say that we are not asking for that in a situation where a flight academy has not given the amount of days that it's supposed to have done or something like that, the client or, the beneficiary of the contract could sue for breach of contract, where you only give me so many days. You have to look at the substance of the cause of action to determine whether or not they are seeking for, the ramifications of faulty training, which takes place down the line. And for the litany of reasons cited in the cases that, we cited, it's too tenuous to link up causation. The courts would be embroiled with telling teachers how to do their jobs, which is not something that this court does or the courts of the state of Texas do.
Any other questions? Thank you, Mr. Harrison. The case is submitted and the court will take a recess.